Alrighty, well, good afternoon and welcome everybody. Thank you for joining us today. My name is Andrew Doffney. I'm the Instruction and Outreach Librarian at the New Jersey State Library, and it's my pleasure to welcome back Larry Metzler, who's going to be starting the first of a two-part series on estate planning, and he's going to be kind of focusing on 14 of the most common mistakes that people run into when they start undertaking their estate planning adventure. So today we'll be covering the first seven, and then next week we'll go through the last seven. So if you haven't registered for next week's program, you can do so on our website. We have it on our events calendar. So please do that so you don't miss out on a lot of the other stuff that Larry's not going to touch on today. Um, so just so for those of you who don't know, Larry Metzler is the president of Apogee Financial Services Group Incorporated and Innovative Retirement Solutions, LLC. He is also founder of the law firm Metzler Law, LLC. His financial planning practice and his law practice are both located in Morristown, New Jersey. His entire career has been focused exclusively on financial planning, estate planning, retirement planning, asset protection, and wealth preservation planning, as well as personal and business tax planning and real estate matters. He is also a member of the New Jersey Bar Association, the Burlington and Camden County Bar Associations, the National Academy of Elder Law Attorneys, and the Society for Financial Awareness and the International Association of Registered Financial Consultants. Larry is also the Society for Financial Awareness chapter president for the Burlington and Camden counties. So again, welcome, Larry. Thanks so much for coming back to speak to our audience. Before we jump into his presentation, we just have a few items to go over. We will be taking your questions at the end of Larry's presentation today, but please feel free to submit them at any time using the Q&A or the chat feature in Zoom. If your question does require some personal information, we ask that you contact Larry directly. That way he can be able to give you a better answer to your questions. Um, there are a few handouts that Larry has given me that I'll upload to the chat. So once we get underway, you should be able to download them from the chat. If you have any problems accessing the files in the chat, don't worry, they will be available in a follow-up email that I'll be sending out, so you'll be able to download directly from there. You will be prompted at the end of the webinar to complete a brief survey. If you have time, we ask you please complete the survey. We always appreciate any feedback that you can give us. And if you do have any financial concerns that you want to talk to Larry about, or you want more information on some of the topics that have been discussed today, you can contact Larry at his email address there, or you can directly schedule an appointment at his Calendly link there. I will send them out in the chat as well so that everybody has access to them. One last thing before we jump into the presentation, I just want to do a brief overview of the Zoom dashboard. This is what your dashboard should look like if you're using a PC or a Mac, but your dashboard may look a little bit different if you're using a mobile device, but all the features will still be there. In the bottom left-hand corner, you can check your audio settings. So if you're using an external listening device like a headset or earbuds, you can check to make sure it's connected properly there. At any point during the presentation, if you have any issues, there's a raise hand button here in the middle. You can click on that and that'll alert me. I will send you a message in Zoom and hopefully be able to resolve any problems that you are having. And lastly, as I mentioned, if you do have any questions, you can connect with us using the Q&A or the chat buttons. You can send those questions to us at any time, and then we'll be addressing them at the end of Larry's presentation. So that is everything that I have for you. So it's my pleasure to turn it over to Larry now.
Andrew, let's get this screen shared here. Okay, hopefully, folks, you can all see the screen. I'd like to welcome you. As Andrew said,
No, the screen is not showing.
no? Oh, got it now, Andrew?
Yes, looks good.
Ah, excellent. Okay. So welcome to the Family Wealth and Protection Preservation Planning. This is our opening slide. The whole concept here, folks, is planning for a lifetime of protection, guidance, and love for your family. I'm going to go through this very, very quickly. This is on the slides. This is just an overview of how our firm operates. I'm not going to burden you with that. Please read it at your leisure. Gives you some insight into sort of our philosophy. Uh, this is an overview, if you will, of the organizational chart. The law firm is on the left, and you can see what we do there. As Andrew mentioned, there's Apogee Financial. We're a registered investment advisor. The Innovative Retirement Solutions is the product side of the business, and the college funding is something we started about 10 years ago to address sort of the obscene cost of sending your kids through college. The whole concept here of these integrated companies is to create, if you will, a one-stop shop. What we found over the years, folks, is that oftentimes your individual advisors really don't know what the other people are doing. For example, your tax prep guy probably doesn't know anything about your estate planning documents. Your investment guy might know anything about your estate plan, so forth and so on. So the overall approach here is to make sure that there's an integration and an overview approach, so that transactionally we make sure that something you do in one area doesn't cause problems in another area. Here's a need sheet, if you will. I would say if you go through this slowly and you're checking off 3, 4, 5, 6 different things, you probably want to sit down with someone and make sure that you address those needs. So, as Andrew indicated, 14 devastating estate planning mistakes. Number one, not surprisingly, is procrastination. And what we hear day in and day out is when it comes to planning, we're all guilty of procrastination. Some of you on the call most certainly are. And we routinely hear comments like, we'll get it done tomorrow. What's the rush? I'm too busy right now. Well, guess what, folks? We're all too busy. The next one is kind of humorous. There's not a year that goes by, we'll get half a dozen folks calling us in a huge rush to get their will and their power of attorney and what have you done. And the first question I ask them is, so when are you planning your trip across the North Atlantic or the Pacific on their first transcontinental or transoceanic visit? They are probably the folks who are most anxious to get everything done like yesterday. The next one, I don't like to think about it, don't want to talk about. We call that sort of the area of procrastination and not really focusing on the reality, so, sort of a state of denial. I'll make sure I put it on my things to do list. If you're like me, things on my to do list, unless I'm really diligent, sort of the lower level ones get put to the bottom. The belief is we think we all have time to get it done tomorrow, next week, or next month. This is a quote. It says, yesterday is a memory and tomorrow is but a hope promised to no one. We all think we have time to get it done, and hopefully that's the case. But if you look at some of the folks I've listed here, I'm sure they all thought they had time, and in fact, they didn't. Tim Russert, the journalist, newscaster, Heath Ledger, the actor, and Nicole Smith, the actress, Lady Diana, Princess of Wales. That's the one that sticks in my head simply because I happen to be watching the TV live when she walked out of that casino, and 5 minutes later, she's dead. I'm sure she thought she had, a very, very nice future in front of her. Michael Jackson, maybe more predictable. James Gandolfini died without a will, died intestate, and you may or may not know there was a lot of litigation that spawned from that fact. Prince, and of course, the most recent one that we may know of, Matthew Perry, the actor. So once again, folks, if you're here on the call today, there's a reason you're here. If you haven't gotten your wills and your powers of attorney and advanced medical directives done, by all means, kind of carry forward with the fact that you're here today, carry forward with that interest and that desire to get that done. Second biggest mistake is just the flip side of procrastination. It's overconfidence. In essence, I had a will and other estate documents done about 5 years ago. Check that off my to-do list and I'm good to go, right? So the belief is once I complete my estate plan, I can put the documents in my desk, safety deposit box, fireproof safe, whatever the case may be. Minimally, once you get your wills and what have you completed, pull them out about every 5 years just to make certain that the dispositive language in the documents is still in keeping with your current situation. Family dynamics change. You may have a new child, a new grandchild, whatever the case may be. Your work situation may have changed, so forth and so on. The relationship with your children may have changed, or with your parents. We don't live in sort of a static society, so make sure you're reviewing your wills at least every 5 years. Your power of attorney and your advanced medical directive, perhaps more frequently. I should caution you, if you have a power of attorney, check in with wherever you have money and find out, for example, do they have a internal rule in that particular company as to when they will not honor your power of attorney? From a statutory standpoint, powers of attorney do not expire. And repeat that. From a statutory or legal standpoint, powers of attorney do not expire. However, there are many institutions out there, their policy is if your power of attorney is older than 5 years, 7 years, 10 years, they will not honor it. And you might say, well, Larry, if that's the case and it's not legal for them to do that, can I sue them? Yes, of course you could. But here's the problem. Typically, when you need to use the power of attorney, it's a situation where it's very, very important you get something done in a relatively short time frame. In order to kind of compel someone to do it through a court proceeding, you have to file a complaint and go through the normal court process. So make it easy on yourself. Wherever you have money, check in with those institutions, find out what their policy is. Whichever is the shortest, just get your power of attorney republished to keep, in context with that particular institution's policies. Safety deposit box. This holds true for any of your important documents. If you're going to store your documents in a safety deposit box, make sure the people that you have appointed under these various documents, for example, the executor under the will, your attorney, in fact, under your power of attorney, and your medical attorney, in fact, under your advanced medical directive, make sure that they are signatories to the box so they can get to your documents in the event something happens. Again, now the year goes by, a couple of people have problems getting their documents out of the safety deposit box because the principal did not put them on the box. Mistake number 3, concluding that making a will disposes of all of my property. The belief is upon my death, the disposition of the bulk of my estate will be controlled by the terms of my last will and testament. In fact, nothing can be further from the truth. In a typical marital situation, at the death of the first spouse, less than 15% of the total dollar value of the married couple's combined estates is controlled by the decedent or the first spouse to die will. It comes as a shock to a lot of people. So let's talk about why that is the case. You'll see here we have 5 different estates. We have the probate estate, the joint property estate, life insurance estate, annuities, if you have any, benefits estate, and we could include a 6th estate called a trust estate. That would be in a situation where someone in your family has set up a trust where you are the beneficiary. I'm not going to spend a lot of time on that because it's kind of off the weeds or off into the weeds vis-a-vis the timeframes we have here today. So let's talk first and foremost about the probate estate. Assets in your probate estate are controlled by the specific terms of your will. There's 3 different types of property that conceptually can be considered probate property. The key to whether or not an asset is a probate asset is the ownership. If an account is in your name exclusively, if a piece of real property is in your name exclusively, it's controlled by your will. So let's go down the list here. Tangible personal property. If you're old enough to remember the comedian George Carlin, he said, we all have too much stuff. So tangible property, tangible personal property is things like furniture, furnishings, automobiles, sports equipment, tools, boats, planes, things like that have, in some instances, title to them, like your car, or in some instances don't have title. So I'm a motorhead, so I have a lot of tools and whatnot, carpentry tools. They're not titled, but reasonable application of common sense would say if I die, my table saw basically doesn't belong to my wife. So tangible personal property, think in terms of your stuff, whether it's titled or not. Intangible personal property, cash and securities. So if you have a bank account in your own name exclusively, if you have a brokerage account in your own name exclusively, your will control the disposition of that property. Real property, that could be a residence, it could be a vacation home, it could be a plot of raw land, it could be a leasehold interest, things along those lines. Once again, characterized by it only being titled in your name. Second estate that most of you will have if you're married is what we call the joint property estate. Property in the joint property estate passed by what we call operation of law or a survivorship type tenancy with respect to the first two. So, sub A, we have abbreviated, stands for joint tenants with rights of survivorship, JTWROS, joint tenants with rights of survivorship. If you are married and your house is titled in joint name, if you are married and have an account, bank account, brokerage account, and what have you, that account will be titled in that format. The second type, TBTE, that's tenants by the entirety. Real estate owned by husband and wife, whether the deed recites it or not, is deemed to be held in that type of tenancy. Once again, JTWROS or TBTE property passes by operation of law to the survivor. It doesn't matter what your will says. It doesn't matter what your trust says. If I was doing this in a public forum, I would say, make it kind of be facetious and say, if my will said upon my death, I leave my joint bank account to my girlfriend, Susie, and my wife, Donna, is the joint tenant on the account, Susie's not going to be a happy gal. I do not have a girlfriend. Trust me, I wouldn't be here on the call today. However, so third type of property, tenants in common. This is the one exception to the operation of law passage. If two unmarried people, or if two married people, for whatever reason, title their property tenants in common, each person is deemed to own a pro rata share. So, for example, if my son and I own an office building together and it's 50-50, when I die, I can leave my 50% interest to whomever I wish. My son Craig can do the same thing. It's not controlled by the operation of law or the survivorship situation. Third type of property that all of you on the call have, life insurance, irrespective of whether it's group term or pure term insurance, whole life, universal, indexed, variable, credit life, or any other form of life insurance. Passes by beneficiary designation. Once again, it does not matter a whit what my will says. My will could say my $1 million term policy, I leave to my girlfriend, Susie. Donna's the beneficiary. Donna gets the money. Cautionary tale here, if there's anyone on the call who has been divorced and remarried, make sure you have gone back and changed the beneficiary under your group life insurance and other policies. Every once in a while, someone will come in, passed away, new marriage, first wife, first husband was the beneficiary, they never changed it. And now we have a lot of litigation. I can tell you categorically, the bright line test is it goes to whoever is named as the beneficiary. No matter what is said or not said, no matter what document is said or not said or published, bright line test goes to the named beneficiary, which you can imagine can cause an awful lot of problems. Annuities, whether they're multiple year guarantees, fixed or equity index, or variable annuities, once again, pass by beneficiary designation. We say contract in both those instances, life insurance and annuity, because essentially what you've done when you have a policy is you have a contract with the insurer. You as the insured and the owner of the policy direct where the proceeds are going to go, once again, whether it's life insurance or an annuity. Your benefits estate, things like IRAs, 401ks, 403bs, profit sharing plans, some pension plans, deferred comp, depending on the language of the plan, once again, passed by contract or by beneficiary designation. It does not matter, again, what your will or your trust happens to say. So if you think in terms of a married couple, how much by way of dollars is in the husband's name? How much by way of dollars is in the wife's name? Compare that to the value of your home or other jointly titled assets, the face value of your life insurance contracts, the face value of any annuities that you may own, and of course, your retirement benefits. Typically, again, at the first death, less than 15% is controlled by the first decedent's will. However, big caveat here. However, think in terms of what happens now after the first spouse passes away. Typically, I'm going to leave all my probate property to my wife. So now what my probate property is now her probate property. What used to be ours in the joint property estate, our home, perhaps our joint bank accounts now are what? They're probate property in my wife's name. She inherited it all. She now has it all in her name. What used to be my life insurance is typically cash or reinvested proceeds from the life insurance policy, a probate asset in her name. Annuities, depending on the terminology of the annuity, if it's a death benefit, once again, that becomes a probate asset in my wife's name. Benefit assets, state benefit assets, typically in by way of a spousal rollover IRA or an inherited IRA. So, what's important about this? People sometimes are very, very concerned about the probate process. First and foremost, probate process in New Jersey is not onerous per se. Clearly, at the death of the first spouse, probate is going to be a relatively simplistic, very short-lived process. Second spouse passes away, because of what we just reviewed, it may be a more elongated process, a more timely, extended process, and depending on the facts and circumstances, could be maybe a little bit more expensive. So just be aware of those facts. In your handout, here's a little cheat sheet you can use to kind of calculate what your probate estate is, what your taxable estate may be. Okay, mistake number 4, failure to understand the significance of how assets are titled. Belief having all the assets titled either in my name or in joint name with my spouse is the way to go, not necessarily because of what we just discussed. In fact, having your assets titled all in your name or in joint name with your spouse could cause your estate plan to fail. It could also cause your estate, in some instances, or some of the assets in the estate to be exposed to the claims of creditors. One of the things you do not want to do is ever have your life insurance payable to the estate. Life insurance payable to a named beneficiary passes to that beneficiary free of any income tax and free of any New Jersey estate tax claims or inheritance tax claims. If somehow the estate becomes the beneficiary, that whole dynamic may change. Let me give you an example. You're newlywed, you have your group insurance, your spouse is named as the primary beneficiary. Several years later, you have a child. Immediately, you should add that child as the first contingent beneficiary on your life insurance policy. If you didn't do that and you passed away, leaving, and let's say you passed away and your wife passed away, that benefit now will be payable to the estate, which can again expose it to claims of creditors. Maybe more importantly, it may result in the estate being left to your spouse's new boyfriend, girlfriend, new husband, or new wife. This comes into play most often in a second marriage, where everything passes to the surviving spouse. You have companion wills. Your wills say each to the other, and then when you pass away, dad's assets go to dad's kids, mom's assets go to mom's kids. But if everything passed to the surviving spouse, could he or she not change the terms of her will and leave it all to his or her kids? The answer is yes. In those instances where you have a blended family, you may want to engage more in a trust planning mode for distribution rather than just a will. For the reasons just discussed, it may also inadvertently disinherit your children and or your grandchildren. Finally, it may result in your estate being liable for the payment of New Jersey inheritance taxes and possibly federal estate taxes if incurred at a rate of 40%. Okay, mistake number 5, failure to take full advantage of the federal estate tax exemption. You're sitting down, folks, for 2024, every person on this call, every spouse on the call can shelter up to $13,610,000 from the imposition of federal estate taxes. Yay, you can forget about federal estate taxes. Belief, 2024, a married couple can shelter as a couple, $27,220,000 from federal estate taxes. That is absolutely the truth. However, we all know that the government's constantly changing the regulations and what have you, whenever the need arises to generate revenue. You'll learn in just a little bit that these provisions will sundown December of next year. What the new regime will be, we don't know. So you want to make doggone sure in your estate planning that both spouses take advantage of the exemption that's given to them. You never want to have a situation where you could have taken advantage to an exemption or a credit, and just by ignoring the issue or not being aware of the issue, you didn't take advantage of it because it may come back to haunt you later on down the road. So in the first decedent's estate, we want to capture as much of that exemption as possible. What do I mean by that? Typically, you want to have that captured in what's called a credit shelter trust. So we're getting now involved in a situation where we're moving a little bit out of the realm of will planning into trust planning. So let me give you a hypothetical. I die today, my estate is $2 million, my exemption is $13,610,000. I have an unused credit of $11,610,000 under that fact pattern. Part of the legislation that increased the exemptions also had a benefit called portability. Portability is a little bit of a complicated concept. I'll make it simple for you. In my fact pattern, I use $2 million. I have left $11,610,000. If my estate files a federal estate tax return to Form 706 and checks off the block, the portability block, that means that the credit that I didn't use now can be used in my wife's estate. Why is it? You kind of sit there and say, Larry, come on. So we're talking about millions and millions of dollars. I don't have millions of dollars. Folks, it hasn't been that long ago that the exemption was $675,000. It was then raised to $1 million, then $1.5 million, and the excess was taxed at that time at 55% of the excess. It's very easy for people right now sitting on this call to have estates, combined estates of over $1 million when you factor in your life insurance. People don't take that into account, especially if it's term insurance, because there's no intrinsic value in the term insurance. But if you die, guess what? That's part of your estate for inheritance tax purposes in New Jersey and for federal estate tax purposes. So the idea here is that even though your estates might not come even close to this amount, when you go through your check sheet, when you add in all the assets to comprise your estate, if in fact it's over $1 million, $1.5 million, $2 million, think in terms of maybe trust planning might be something you want to engage in so you can take advantage of the benefit called portability. As I said earlier, this benefit is going to sundown December 31st of 2025, unless Congress acts to maintain the current level. I don't think that's going to happen. I would say most folks are thinking in the range of somewhere between $2.5 to $5 million per person. Again, that seems like a lot, but depending on your situation, how much life insurance you have, so forth and so on. Also, keep in mind when you're doing your planning, any anticipation of an inheritance from family members, whether they be parents or grandparents, when you go into these calculations of your estate. Mistake number 6, failure to take full advantage or to understand, take full advantage of the benefits of a revocable living trust. So what is a revocable living trust? Let's talk about that first and foremost. And to do that, we have to kind of think in terms of what is a trust, just generically speaking. A trust is nothing more than an estate planning tool that is formed more under contract law than probate law. What do I mean by that? Probate basically is founded under English common law, the will litigation revolving wills, typically under English common law. Most of the states, I'll say with the exception of Louisiana, which is settled under Napoleonic law, follow the general common law principles. So in fact, anybody can contest a will if they decide to do so. And when does that happen typically? This is a common practice in situations where there's an estranged family member. So Johnny's been estranged from his family for the last 20 years. Mom's passed, dad's on his deathbed. Johnny shows up and says, hey, I had a phone call, conversation with dad, and we're all good now, and dad was going to leave me part of his estate. Well, we all know that's a lie, but is there anything to prevent Johnny from filing a caveat to prevent the probate of the will or a complaint basically alleging those facts? The answer is no. So the attack on the will is relatively easy to do. Typically, they're not successful, but the intent is not to be successful, and the claim is to extort money from the estate. So, having said that, how is a trust different than a will? Trusts are formed more under contract law, and there's always three parties to a trust. There's a person called a trustor, a settlor, or a grantor. Those terms are used synonymously. Think in terms of who is the person that's establishing the trust in the first instance. So if I'm the grantor, I'm going to set my trust up for the benefit of a second party to this contract called the trustee. The trustee basically is the person or entity that's going to carry out the rules and regulations as set forth in the trust document for the benefit of the third person called the beneficiary. Now, if we're talking about a revocable living trust, and this gets really kind of weird here, I can be the grantor, the person who sets it up. And because I don't want to give control of my assets to anybody else during my lifetime, I can be the beneficiary. And because I don't want to give some third party control over the management of my assets, I can name myself as the what? Trustee. See, here I am. Larry is the grantor, the beneficiary, and the trustee of this trust. I am, under the law, considered to be three separate legal entities. However, I'm still the same person, correct? So I kid, or I say facetiously, it's kind of a schizophrenic relationship. You can have some great conversations with yourself in the shower in the morning about what you want to do with your money. So, what can we do with a revocable living trust? First and foremost, I can capture whatever the federal exemption happens to be upon my death, only upon my death. I can prevent non-probate property from becoming subject to probate upon the death of my spouse and I. I can avoid any and all probate fees and costs. I can also avoid any public disclosure. When someone's will is probated, anybody can go to that particular surrogate's court, if we're talking about New Jersey, and get a copy of the decedent's will and find out what the specific terms of the will happens to be. Many of us don't want that to happen, so a trust can preclude that from happening. When a trust is prepared, it is not filed anywhere. It is not probatable when the person passes away. A trust can also avoid the delay in the process of your spouse's access to assets and income from those assets upon the first spouse to pass away. Let me give you a hypothetical of what happens here. So let's say my wife and I have a joint bank account and I pass away. Technically, she owns half of the account, but if she went into the bank the day after I die and said, I want to close the account out, the bank will not let that happen. They will allow her to have half of the assets. The remaining half has to be converted typically to the estate of, in the name of me, the estate of Larry Metzler. And then upon the settlement of the estate and the receipt of disclaimers from the taxing authorities, then that account will be turned over to her. Same is true of many other assets that happen to be in joint name. In addition, it can provide a tax-effective mechanism to once again capture the equivalent exemption at the death of the first spouse, and therefore guaranteeing that you're minimizing both spouses' federal estate tax exemptions and minimize the impact of any federal estate tax, if any. What do I mean by that? You all know I have an exemption, roughly 13 million bucks. And in my fact pattern, I said I'm going to capture 2 million of that. If I left everything that I owned, but one way or another, either through my will, through joint tenancy, or through beneficiary designations to my wife directly, have I not basically waived my ability to capture my exemption when I died? The answer to that is absolutely. She got everything one way or another, meaning I didn't capture what Uncle Sam gives me for federal estate tax avoidance. Moving on, can provide a tax-effective mechanism to create what's called a standard marital deduction or a Q-tip marital deduction upon the death of the first spouse. This is a little bit off in the weeds, folks. Let me give you an example where this is used quite often. There is an asset in the estate that the grantor and or let's say the decedent wants to keep in the family for future generations. More typically, this could be a vacation home. It could be a painting. It could be some other asset that's an antique or something that for whatever reason the family wants to keep it in the family going forward in time. The trust can provide that as a carve out, if you will, and still qualify for the marital deduction, which is basically the deferral of any federal estate tax until the second spouse passes away. It can also provide a carve out separate trust, if you will, for special needs children. We're seeing a lot more of that today. Kids who they're on the spectrum, they have some needs, and you want to make doggone sure that upon the death of both spouses, that child never gets more than $2,000 in their name, because that will basically disqualify them for any governmental benefits that they may be entitled to or may be currently receiving. Provides a tax-effective mechanism to create what are called generation skipping trust, bloodline trust, or dynasty trust upon the death of the first or second spouse. A dynasty trust or a bloodline trust basically says, hey, look, what my spouse and I bring into our marriage, we never want to get it into the hands of our in-laws. So we want to make doggone sure that when we both pass away, meaning mom and dad, that only our children, grandchildren, great-grandchildren benefit from our life's work. That's one of the most common reasons people go into revocable living trust planning, aside from the lack of probate or the avoidance of probate. Can provide protection of beneficiaries' assets from creditors, future spouses, divorce of children or grandchildren, and poor judgment by immature beneficiaries. Okay, let's take it one at a time. Beneficiaries' assets from creditors. You may have children, or you may know of people who have children who just never grew up or not mature. And if they got a large inheritance, it would be like a lottery ticket. And, X years later, it's gone, it's squandered. I would say families who have more than 3 children, odds are one of them fits into that category. So you could, for example, the very responsible child A and B, give them their distributions outright, and child C, who's a spendthrift, put their money into trust to be dispersed over a longer period of time. And you may think, well, oh my goodness, Larry, that's a really great idea. I kind of relate to that situation. But that child, in my instance, the C child or the spendthrift child is going to be mad at me. Well, guess what? If you have kids, doggone well, you never treat your kids exactly alike. And there's no doubt in my mind that your children over the years have gotten very disturbed or very angry with you. So what? This is your estate. This is your money. They've been mad at you before. You want to do what's right for them, irrespective of how mad that you may think they may be. I say that facetiously, but also with a degree of seriousness. Moving on. So that's the creditor protection. Future spouses, black letter law, folks, whether you form a trust or not. In your papers and what we call your letter of last instruction, which is an ancillary document we provide to our clients that talks about, among other things, what do I want to happen when I died? What services do I want? If I'm a veteran, do I want to have a veteran ceremony, cremation, burial, whatever the case may be? In that letter of last instruction, you also want to have a reminder that says, hey, kids, please remember that anything you inherit from us, if you do not commingle it with the assets of your spouse, will never be subject to equitable distribution in the event that we get divorced or you get divorced. Let me repeat that. If you do not commingle inherited property with marital property, those inherited assets will never be subject to equitable distribution in the event of divorce. Divorce right now, folks, is between 50 and 60% for people, young folks getting married today. So given that, you can kind of think in terms of this is appropriate or beneficial to you. Can provide minimization of New Jersey inheritance tax. We'll learn later on right now that inheritance tax applies only to those people who are not what we call Class A beneficiaries or charitable beneficiaries. So let's focus on that. Who are Class A beneficiaries? They are spouses, children, grandchildren, great-grandchildren, so forth. So think in terms of mom and dad, and then lineal descendants. Those are all Class A's. Charitable, Class E's speak for themselves. Everyone else who's not in those categories are considered Class C beneficiaries. That's a 15% inheritance tax. So siblings, nieces, nephews, grandparents, parents, so forth and so on. If you leave money to those classes of beneficiaries when you pass, that's a 15% tax. Other than that, for the most part, New Jersey, unlike PA, is a relatively tax easy state. Note at the bottom, in order to guarantee your estate plan is going to function as intended when you need it most, that's obviously at your death, your trust or your will must be properly funded. The way you hold title to your assets and your beneficiary designations must be coordinated with the dispositive provisions of your will or your trust. Okay, mistake number 7. Failure to understand the relationship between the federal estate tax exemption and the New Jersey estate tax. There is congruency today between the federal estate tax and the New Jersey estate tax exemptions. Since 2001, there is no congruency, meaning that they don't pattern each other, they don't reflect each other's numbers. As was previously stated, federal estate tax exemption 13.61 for each individual. For New Jersey estate, as of January 1st, 2018, New Jersey eliminated the estate tax. Prior to that, the estate tax was anything over $675,000, and the tax started at about 4.8% and was on an ascending scale. I will suggest to you that's the current law, so we can speak to that. I would not say with absolute certainty that sometime in the future, New Jersey will not reinstate the estate tax. What happened was there was a kind of an agreement between the Dems and the GOP that giving up the estate tax in lieu of a increased gas sales tax, that was the quid pro quo for that being enacted in 2018. So who knows what's going to happen in the future, but that's the current law today. Once again, to reiterate, for New Jersey inheritance tax purposes, any transfers at death to any non-exempt or non-Class A beneficiary are taxed at 15%, possibly more. All right, folks, so that's the first 7. So let's open it up to any questions that any of the folks may have.
All right, great, Larry. Thank you so much. We have a few questions coming. So please, if anybody does have questions, you can use the chat or the Q&A to send us the questions, and we'll be happy to address them. If you do not want to include a blood relative in your will, is it best to just not mention them in the will, or should you specifically state that they are not included in the will?
Absolutely specifically state that they're not included and the reason. So, for example, my son John and I have been estranged for the last 20 years. I specifically disinherit him. This is not I have not admitted him involuntarily or any other manner. Another thing you can do is leave him $1. With that caveat, I leave my son John $1, recognizing that we've been estranged for the last 20 years. This is not an oversight. This is not a misstatement in the amount I want them to receive. Something along those lines. Don't leave it blank, because that opens the door basically for an averment that says, hey, it was a typographical error. You just left me out by mistake.
All right. What is your opinion of commercially available living trust software?
Oh, good Lord. You get what you get. And one of the things I would suggest, if it's fairly decent software, meaning it's fairly deeply integrated, there's going to be a question that says, do you want a crummy provision in your trust? And I will tell you, just by virtue of that word, people are going, no, I don't want anything crummy in my trust. Well, that happens to be a court case. It's crummy with a capital C, called Crummy versus the Commissioner. And that goes to gift tax issues. So if you are conversant with all the rules and regulations and statutes and you feel comfortable doing that, by all means do so. But I will say you get what you get.
Under what circumstance is a revocable trust claim where it can be touched by the court?
A revocable. Okay, so I'm not sure what context, but let's say that you're alive. Okay, so you're alive. The revocable trust, because you are all 3 of the entities that we talked about, the grantor, trustor, beneficiary, any award in a court situation, they would be able to attach any assets in your irrevocable living trust. The only way, quite candidly, to preclude attachment by a creditor on your assets is to not own them, meaning they're transferred to an irrevocable trust or to an individual. And that transfer was not to avoid a creditor. For example, litigation, you were in a car accident, you killed two people, and you know that a wrongful death suit's coming around the corner, and you attempt to transfer all of your assets to a third party. That's called a fraudulent transfer. It will never hold up.
All right. We had a couple questions about things that if asking if you'll cover in the next session. One was about discussing codicils, and another one would be choosing an executor.
Oh, we can, yeah. Codicils we could talk about today. So codicil is basically a formal amendment to your trust, or excuse me, to your will. In essence, all it is, it says that I'm changing the language in paragraph X, and I want this new language to replace that language that I am now deleting. I would suggest to you that's a good way to make a change. I'll suggest to you after you do the first one, if you're contemplating doing a second one, republish the will. Because Murphy's Law will say, the person passes away and codicil number 2 can be found, but we can't find number 1. Folks, you'll be amazed at how many times when someone passes away, they can't find the original will, let alone 1 or 2 or 3 codicils.
And any thoughts on how to choose an executor?
We're
Or
going to
would you
talk
be good?
about that next
Okay,
session.
great. All right, let's see. A parent purchased insurance for an adult child, but the child dies before the transfer of policy took place. Does the insurance payout go to the adult child's estate, or is it retained by the parent who had been paying the policy?
Irrespective of who, so let me make sure I understand. So the beneficiary died before the insured. I think that's what I heard.
Yeah, it says the child dies before the transfer of
Okay.
policy took place.
Okay. So I don't know about the transfer. So if I name my son as beneficiary of my life insurance and he predeceases me, then whoever is next named, the next contingent beneficiary, when I die, would receive the proceeds.
Can you be the trustee of your own irrevocable trust instead of revocable and
No.
irrevocable?
Well, put it this way. Yes, that would be a major malpractice issue right there. No, irrevocable means irrevocable. Typically, the reason that you're setting up an irrevocable trust is you do not want to have anyone have any access to those assets, or maybe again for special needs purposes. So no. The very idea of being a trustee means that possibly you could change the terms of the trust. So no, you can't be your own trustee in an irrevocable trust, or you shouldn't be, I should say.
Is it best to have both a will and a trust, including those who are single individuals?
If again, if you look at the benefits of the revocable living trust, if you those benefits resonate with you, the answer is yes. So for example, if you say, "Hey, look, I want to keep my affairs totally private. I don't want anybody to know what I have or where it went," and you're single, sure. I mean, a revocable trust would do that for you. It will avoid probate, avoid publicity, and it will also address some of those other issues that we talked about, like spendthrift provisions, creditor protection privileges or provisions, things along those lines.
Um, the next couple questions have to deal with assets and trusts. I don't know if you're going to be covering this later, but is there a hierarchy for transferring assets into a trust?
Oh boy. Yeah, I would say yeah, certainly. To the extent that other than your emergency funds, there's no reason in the world why, if you have, for example, a personal investment portfolio, you wouldn't put that in your trust. Um, if you had large balances in your checking account or in your savings account, putting those in a trust. Um, However, now if you're married, and again, this is more of a complex issue. you want to balance out the values of the estates because we don't know who's going to predecease the other. And again, if we're focusing on the potential reinstitution of the federal estate tax, you want to have equal amounts of assets in each of the spouses' estates. So what I wouldn't do, for example, is put my residence in because that may cause some problems for insurance. It may cause some problems for if you're a veteran getting a veteran's benefit deduction on your real estate taxes. So it may be an insurance issue, maybe a tax issue. Typically, what happens is after the first spouse passes, then we put the residence into their surviving spouse's trust. Because remember, at the first spouse's death, that joint tenancy on the house is not probatable. It would be in the second spouse's estate.
Um, and then what type of account should we put the trust assets in? Should we use a basic savings account just to keep the money safe or put it in an investment account and try to grow the money?
Oh boy. Okay. Now you're getting into the integration of the various entities here. So that is a retirement investment situation. So I would say that now we're getting into more of a estate slash retirement. So savings account right now is probably earning, interest that may keep pace with inflation. Okay. Who knows, 6 months from now, a year from now, or if I go back 4 years where a savings account, you're getting like 1/10 of 1% of that by way of yield. Um, Keep in mind, you always want to have your emergency fund, depending, whether both spouses work, one spouse, two spouses, 6 to 9 months to 12 months of emergency money. I would say that should be in a high yield money market account. Savings account, again, unless it's yielding, you know, a reasonable rate of return, should be invested. Now, how it should be invested, that's an issue of risk return. And where are your other assets invested? Where's your 401k invested? Where's your IRA invested? If that makes sense.
Can a beneficiary also be an executor of a will?
Sure, absolutely. Very common. In my case, for example, my wife's the primary executor. She's my primary, and then my son and daughter are co's if she's alive or passes simultaneously with me.
Um, do you see any more questions in right now? We can give it a few more minutes, but what's maybe one of the most common issues that people come to you with when you're dealing with estate planning?
It depends what life stage they're at, Andrew. So newly married couples typically, to be perfectly frank, probably don't even have wills until they get their first child. Then the issue is focused on the child almost exclusively, who's going to be, and that's typically a guardianship issue. So they get simple wills, they appoint the guardians, they appoint their executors, um, and so forth. So early stage marriage, young kids, typically the focus is on, God forbid something happens to us, who's going to take care of the kids? So now let's go fast forward, you're in your mid 40s and the kids are in college or getting out. Now it's more of a situation where we're looking a little bit further down the road in a situation where there's premature death. So that's when folks typically start thinking about more elaborate trust planning. By that time, they have some sense of the maturity of their kids. Can they handle money? Can they not? Should we give a distribution outright upon our death, or should they be staged out, 26, 30, 35, whatever the case may be, simply because we don't want to have a sort of the lottery ticket situation presented. Then you get into, let's say 50s, 60s stage now. Longevity sort of is coming into play here. Do we start looking at some form of long-term care issues? Is that an issue genetically in someone's family that we have to start addressing those issues? Health issues sometimes have come to the fore, and so forth and so on. So I would say typically think in terms of where the person is in their life cycle kind of controls the complexity of their affairs, because obviously as we get older, we accumulate more assets, so forth and so on. The tax laws change. I mean, the most recent example has been, the Secure Act 2.0, which changed basically the distribution of inherited IRAs. That's made a major change in how people think of their planning, not necessarily exclusively from an estate planning standpoint, but from also an income tax planning standpoint. And one might argue, well, what the heck does income tax planning have to do with my estate planning? It's depending on the balances in your retirement plans. It's a lot. The answer is a lot. Because Secure Act 2.0 basically says that if I pass, my wife passes, I leave any values or balances in my 401k or IRAs to my kids. They have to take that money out over 10 years minimum. Whereas prior to Secure Act 2.0, they could take it out over their life expectancy. And as you can imagine, if my kids are in their 40s or in their 50s when I die and their life expectancy is 80, forcing that money to be taxed, distributed and taxed earlier has huge income tax implications. So again, typically it's life cycle and sort of the issues that arise with respect to a family, where they are in that life cycle.
What thoughts do you have for protecting a minor child if you do not have any family nearby? This would be like, what would you kind of put in a will to help with that?
Okay. Um, the issue probably turns more on who you trust to be able to be the guardian of the child. Um, and again, if both spouses have passed away, the key issue there is who is my child going to live with, and do they or do they not have expertise in managing assets, so forth and so on. And I would say experientially that breaks about 50-50. Some folks are lucky enough to say that the person I choose to raise my child, should my wife and I pass away, also has expertise or certainly enough common sense to hire good expertise to manage the child's assets. If that's not the case, then who's the child you're going to, or who's the person you're going to pick to raise the child? And you can have another person who doesn't necessarily have to live in the area to manage the assets for the child. There's no requirement of residency for the person who's managing. It's called the estate of the child versus the person of the child. Guardian of the person is who's going to raise the kid, who the kid's going to live with. Guardian of the estate is who's managing the assets. Many times, families want those to be two different people. Now, if the question is the person who's going to raise my child lives in Kentucky, well, then you have a choice. Are you going to ask the person to move here, or is the child going to move to Kentucky? And that's a tough decision to make, but it is what it is.
What are your thoughts on an irrevocable trust?
I would have to know the reason someone's thinking about doing irrevocably. Once again, and this is, I would say, it has to be for a reason that's compelling for you to give up total control and dominion of your property. I mean, make no bones about it. You transfer property to an individual or to an entity, meaning an irrevocable trust. That's it. You no longer have any control over that property at all. So that's a pretty extreme situation. What we do irrevocable trust planning for special needs people so that they can stay on their entitlement programs. And for very, very wealthy people who don't want their life insurance proceeds taxed for federal state tax purposes. So if I have a client that's got a $13 million estate, and they've got a $10 million buy-sell policy, and they don't want that 10 million bucks coming into their estate being taxed in excess of 40%, then we're going to set up an irrevocable trust. That irrevocable trust becomes the beneficiary of that $10 million policy. And the language of the trust basically distributes the income and principal to the family, typically to the surviving spouse and children, just as if it would have had it passed through their estate. But I would say be very, very, very judicious about doing anything irrevocably until you completely understand, the import of what that really, really means.
What type of policy should a 50-year-old have?
Life insurance? Life
Uh,
insurance
I,
policy, I
I, I,
assume?
I don't know.
Okay, so here you go. That gets in the area of how much life insurance does someone need. And I'm going to tell you, there's nobody on this call who's overinsured. Rule of thumb, okay? And I'll give you a current reasonable rate of return. You can get a 5-year CD in most banks today for let's say 5%. Okay. So if my salary is $100,000 a year, how much life insurance do I have to produce a principal sum earning 5%, or right, 5% of what is $100,000 a year? It's $2 million. The amount of life insurance to create a replacement of your income is inversely related to the risk-free rate of return. So if I use 5%, $2 million gives me 100 grand a year. What if the rate of return is what it was 4 years ago, 2%? Well, I would divide $100,000 by 0.02, not 0.05. And that would give me the principal sum I would need. Add to that any debts that you have and what you plan on spending for your kids' college education. And the numbers become very, very large. Having said that, therefore, if you are a young couple, middle-aged couple, you can't afford that much in permanent insurance. So now you're looking at term insurance to cover that contingency. That's an answer most people don't want to hear, but that's the correct financial planning answer.
Who do you suggest as a trustee for an irrevocable trust?
Say again, Andrew, I didn't hear that.
Yeah. Who do you suggest as a trustee for an irrevocable trust?
Um, who do you trust with your life? Same as any other fiduciary. So, um, wife, husband, mature child, brother, sister, mother, father. Can't come to any of those, then you can pick an institution, some trust-centered bank. I worked for Wilmington Trust Company and Provident Bank back in my early career. And I would say, especially Wilmington Trust, a lot of the old moneyed families in Wilmington area used a corporate fiduciary because they didn't want to have any bad blood between, I have 4 kids, I named one as the trustee, and that trustee's making distribution determinations for the other 3 kids. That's a prescription for bad blood, as you might imagine. So if you can't come up with somebody who you trust with your life, you can also always choose a corporate fiduciary.
Is it best to see both a lawyer and a financial planner?
Oh, without a doubt. Yeah. Yeah, sure. You want to make sure, and that if you go back to the original slide of sort of our affiliated companies, I built that out for that very purpose because what was happening was, and again, this goes back to my corporate days. It goes back to one hand doesn't know what the other one's doing. Your accountant or your tax preparer, you rehire that person based on the amount of taxes you pay or don't pay. Paying less taxes might not be in your best interest, believe it or not. That goes to the issue, should I be contributing to my Roth 401k or my traditional 401k? Should I have a traditional IRA or a Roth IRA? That is not necessarily a current year tax preparation decision. It's more of a long-term retirement planning issue that's integrated with my estate plan. Guys, if you're still on the call, I highly advise you, stay away from transactional thinking. Transactional thinking is I'm looking at making a decision that affects one area of my overall planning. If you don't know how that decision may affect other areas of your planning, talk to somebody that can answer those questions for you. And the analogy I'll give you, it's a stupid analogy, but it's the only one I can come up with. If you looked out your window and said there's a big placid pond out there, and Larry throws a cinder block in that pond, excuse me, what you're going to see is a big splash of water. that's the transaction that you're contemplating doing. But what about the ripples? If you don't understand the ripple effect, where it may ripple into other areas of your planning, you need to make sure that the people you're talking to do. So the answer is yes. And make sure if you're talking to a financial planner and you have estate documents, that planner reviews those estate documents and is competent enough to review them and understand the import of them, and vice versa.
What is the typical cost for estate law representation? How long should it take and how is billing arranged?
Is this in a situation where someone passed away, or this is just in doing a plan?
I don't know. I will see what they respond with. While we wait to get some clarification, for a newly married person in their early 30s that doesn't yet have kids, what should we be focusing on? Just a will for now?
I would say yes. I mean, again, depending on the assets that you have, if we're saying, hey, your early stage, you don't have large accumulations in your retirement accounts or in your personal accounts. Typically, it's what I call a basic estate plan, simple will with guardianship appointments, advanced medical directive, powers of attorney. That's what I call an estate planning 101 plan for a young couple.
It was for the estate law representation was somebody had passed away.
Oh, okay. Um, you want to get that by proposal, and you've got two choices. You can do it by the hour, okay, or you can do it by the statute. So the statute basically typically is going to generate the higher fee. I would advise basically think in terms of by the hour with a cap. So any experienced estate planning lawyer who works in this area, based on the specific facts of that situation, should be able to give you an accurate, no more than quote, if that makes any sense.
All right. I don't see any other questions, so I think we can go ahead and end it there. There's a lot of stuff discussed. So, and I'd just like to invite everybody back next week. If you haven't registered for the part two, it's going to be next Wednesday at the same time. And I put Larry's contact information back in the chat. So um, if you want to reach out to him for any specific questions or if you need follow-up, please feel free to do that. So again, Larry, thank you so much
Oh,
for coming
thanks.
back,
Thanks,
and we can't
Andrew.
wait for part two.
Thanks for everyone attending, and see you next week, guys. Take care.
All right.